Good evening again, Attorney Tim Hollister, Allen and Snyder in Hartford. I'm here representing Thomas Montanari. I'm proud to say that I actually did some work for Mr. Montanari's parents 30 plus years ago. Wonderful clients and very welcoming, and my understanding is they were bedrock citizens of Richfield. I filed a memo dated January 17th, and I'm just going to highlight it. I'll try to do this in 3 minutes. I might be a little over. The purpose of this memorandum is to explain the law governing municipal moratorium and how this proposed moratorium is illegal in several respects. At the outset, it's important to recognize what a moratorium is, a zoning moratorium is, and why one may only be imposed in specific, narrow circumstances. A moratorium is a suspension of property rights. It is an action taken by a municipal commission that temporarily overrides state real estate, real property, and land use law. There is no provision in the general statutes that allows a moratorium. Our Supreme Court has said, therefore, only a moratorium is allowed in compliance with strict, specific, and short-term requirements, and only when necessary to address a specific problem with existing regulations. The Court has said that a moratorium may not be imposed to stop or pause a broad spectrum of development, but to assist in the administration of regulations when a specific issue arises, and then only as necessary to fix the problem. The best recent example of this is cannabis retail stores. When cannabis was legalized statewide, few, if any, towns had regulations in place to control the opening and operation of stores. Short-term moratoria on the order of 3 months were thus permissible for the specific purpose of allowing time to draft and adopt regulations where, for good reason, none existed, and avoiding the problem of unregulated stores. But only such limited and compelling circumstances warrant a suspension of applications and property rights. Now, the next section of my memo is what the chair referred to earlier, going through the sections. I'm going to omit that, and I will go to the first of 3 reasons why this isn't valid. Zoning moratorium must be limited in scope and duration and must address a specific defect in the existing regulations that justifies a temporary suspension of rights of property owners under state law, citing the case of Arnold, Bernhard and Company versus Westport. In the Arnold case, the court upheld the zoning moratorium suspending applications for specific business uses within a specific 14-acre tract within Westport's business district. The court held that the moratorium was properly limited in scope because it only restricted development in only a specified portion of land in the town and only for business uses. It was properly limited in duration because it expired after 9 months. The moratorium addressed a specific defect where the existing zoning regulations had permitted, quote, the rapid expansion of business uses, unquote, in the identified location, and the commission gave sufficient but not excessive time to draft revised restrictions to control the potential impacts not addressed by existing rules. Now, compared to these standards, the illegalities in the proposal now before this commission are numerous and breathtaking, and include the following. It does not explain or reference when or how the commission determined the need for a moratorium. It does not identify any specific concern, problem, regulation defect, or recent problematic application that requires correction or revision. Its wording is consistently broad, vague, and undefined. Its statements of scope are open-ended, such as including but not limited to. It prohibits an application for a zone change, regulation amendment, or special permit, regardless of the use proposed, the complexity or simplicity of the application and the impact. Though stated as a moratorium on zoning, it also includes review of the Plan of Conservation and Development, which was adopted only 4 to 5 years ago, and the POCD adoption is generally a very lengthy process that can easily exceed a year, and I would add it's undertaken by a commission in its planning, not its zoning capacity. The proposal inexplicably and arbitrarily exempts municipal or government uses without defining what they are. It covers every zone in town without geographic limit. It applies and prohibits small, minimal impact proposals despite its stated intent of reviewing only complex applications. And it states that the Commission's review will cover infrastructure and resources and the availability of reliable consultants, neither of which is a matter involving zoning regulations per se, and the inquiry into infrastructure and other resources is likely to intrude on the board, the powers of the Board of Selectmen and other town agencies. And I'll digress here and say, if you're thinking you're going to look at sewers, please be advised that sewers cannot be used to control land use. Our courts have been very clear about that. You are the zoning commission, you are not the WPCA, and you cannot tell the WPCA what to do. And so the moratorium's time limit exceeds the length that the courts have sanctioned. The moratorium is demonstrably overbroad, vague, and open-ended. Now, I saw on the town website the other day, I thought it was from the First Selectman, a concession that the moratorium cannot and will not prohibit 830G applications. Mr. Chair, if I understood what you said tonight, that the Commission is now not taking a position on the applicability of 830, of the moratorium to 830G, but will resolve that on a case-by-case, application-by-application basis. What you're really saying is we're going to include 830G in the moratorium and grant exemptions from it on a case-by-case basis. So you are doing something that is so clearly illegal. Even if you say you're not taking a position, you actually are, because you are including 830G in the scope of what you're banning, at least until you release it from the ban going forward. It's very clear that 830G cannot be subjected to this moratorium. Finally, third point, this moratorium also suspends several sections of Public Act 21-29 by temporarily banning multifamily housing and the rules intended to promote it. Public Act 2021 number 21-29, Section 4, amended the Zoning Enabling Act in 5 specific and important provisions. The first is, quote, address significant disparities in housing needs, unquote. 2, provide for the development of housing opportunities, including opportunities for multifamily dwellings, for all residents of the municipality and planning region in which the municipality is located, unquote. 3, promote housing choice and economic diversity in housing, including housing for both low and moderate income households. 4, expressly allow the development of housing which will meet the housing needs identified in the state's plan, consolidated plan for housing and community development. And finally, 5th, General Statutes 8-2 sub D sub 8 provides that zoning regulations, quote, may not place a fixed numerical or percentage cap on the number of dwelling units that constitute multifamily housing over 4 units, middle housing, or mixed-use development that may be permitted in the municipality, unquote. So that very last one, the 5th one, is very important because what you're proposing runs head on to that. So the reason for my bringing those 5 points up is you have this Keller Court case from Westport from 30 plus years ago where the court allowed it in very limited specific circumstances based on there not being anything in the state statute. Now you have 5 sections of state law that run headlong into what you're proposing in terms of banning multifamily housing, and I believe it would. The Supreme Court, if it were confronted with the issue today, would not allow this moratorium based on what the legislature has done 4 years ago. So this proposal is illegal and cannot be adopted. The last thing I want to say is I sent each of you a Freedom of Information Act request dated January 10th. It was distributed to you by Ms. Dew several days after I filed it. I would ask that this hearing be kept open until the commissioners have a chance to reply. And the purpose of it, as stated in my letter, is to make sure that all the communications to you or from you regarding this proposal should be part of the record.
Thank you, Mr. Hollister. Your contributions are very appreciated, detailed. I would only make one response, just for the record, that I don't agree with the way you restated my position on behalf of the Commission. on the 830G position. I think what I said, and I think I said it more than once actually at this point, is that the 830G is not the focus of this moratorium, either in draft or intent. And tonight, at least in tonight's public hearing, I'm certainly not going to, and I encourage my commissioners also to not prejudice our ultimate outcome. We may or may not take a position eventually. I think what I've tried to be clear about is that we don't have a position on the matter right now. So
and all I'm saying is the numeric minimum criteria of your proposal will catch 830G.
And
so you're saying you're banning that until you exempt it.
All I'm saying is stay tuned. We're not taking a position.
Thank you.
That's what I'm saying, rather than taking a position. Thank you.